Are you an injured worker in California and you have a workers' comp case that just seems to be taking forever? Or are you an applicant attorney looking for a way to quickly get your case resolved for your client's best interest? There's a fundamental word you need to understand, and it's called due process. An injured worker has a constitutional right to due process. And a lot of people say this word, but they don't know what that word means or how to use it. I'm going to explain in this video what it is and how you can use it with a real case that I'm in the middle of trial now. Hi, my name is Michael Burgis. I'm a certified legal specialist in California workers' compensation. I'm a trial attorney and I'm the managing attorney of MB&A. What is due process? If you're an attorney or even an injured worker, maybe you've heard this phrase. Most people don't even know what it means, or if they know what it means, they don't know what to do with it or how it works in context. But due process is this. You can't have a taking without due process. And there's procedural due process and substantive due process. But I'll just make this easy. Due process is this. You have a right to life, liberty, and the pursuit of happiness, and it can't be taken from you without due process of law. And both parties have due process. And most people don't realize that due process is not static. What it means is it's a moving target, and I'll explain. In the workers' comp context, and I'm gonna put an example of a case I'm literally in trial now on. I have an injured worker who I'm arguing has a brain injury, and he's not getting the money he needs to survive. And I'm arguing he's 100% disabled. And 100% disability is 2/3 of his salary for the rest of his life. But instead of paying that, the insurance company is paying him $290 per week. Now, the defense is not ready for trial because the record right now, the way it is established, I believe my client is clearly entitled to a 100% disability award. And they don't want to go to trial based on that record. So what they want to do is further develop the record, kick the can down the line to see if they can find some information to reduce their liability and make it so that either I can't successfully argue for 100% disability or that there's valid legal apportionment so that my client is not entitled to a 100% award. So, relative due process. The defense says, hey, I have the right to conduct discovery. He's asserting that he's 100% disability. That's a lot of money. I have the right to conduct discovery, to get all of the relevant records, and to be afforded my due process to make sure I have a fair chance at litigating this case. And if I'm able to, if the injured worker is entitled to 100% disability, so be it. But I have the right to investigate to see if I can, fight the case the best way I can. Injured workers due process. They have a constitutional right under California Constitution, Article 14, Section, 4, that basically says you have a right to an expeditious resolution without encumbrance. Right? What does that mean? Injured workers due process is to have a quick resolution and administrating the benefits they're legally entitled to. So there's due process. He wants a quick resolution. They want to keep delaying it to find information that could help their case. So where is it, right? The truth is you have to look at both parties' respective due process and their respective positions and their respective detrimental impacts if one person is afforded their due process over the other. So let's do that analysis here. And you also have to look at diligence. Was somebody afforded their respective due process and they didn't act diligent, right? So obviously the law is going to reward the person who's diligent and penalize the person who's not diligent. And again, you look at respective due process. So this is how a good attorney should frame the issues utilizing constitutional due process to make sure to close discovery and get you to trial and get that benefits quickly, okay? Now, framing it. The defendant's due process, in this case, is the County of Los Angeles. They want to conduct further discovery, but it's been over 5 years since the injury. So I'm able to show that they had plenty of times to do what they wanted to do, to depose my client, subpoena whatever records they thought were necessary, send these to all the agreed medical examiners, and that they failed to act diligently. But their due process is, hey, we want to see if there's some information that could minimize our exposure, and we believe we've acted diligently. Inversely, counter, the injured worker has a brain injury and should be receiving 2/3 of their salary, and they're getting $290 a week. look at that respective due process. Your Honor, if we afford defendant their asserted due process, my client is absolutely violating their due process, and this guy may not be able to eat. Luckily, this client doesn't have children, because there's no way that an injured worker like this would be able to support their family. But the relative due process, I mean, it isn't even a question here. So if you're an injured worker or you're an injured worker's attorney, due process is one of the biggest swords you have to get justice for your client. And I rarely hear anyone argue due process, yet alone, cite to it in briefs. But the way you can get discovery closed and get a trial date is by accurately framing the issues on due process and how defendant's asserted due process is a per se violation of applicant's due process, and applicant's due process should supersede given the respective positions and detrimental impact. I hope you found this video helpful or informative. If you have any questions or concerns, obviously we're here, we're standing by. We issue new content to stay apprised with the law and stay a step ahead of the defense attorneys in these insurance games. So again, if you like it, please like and subscribe below, and feel free to give us a call. We got the answers and we're here to help.